All right, let me see another one writing. Marianne, if you want to, you may start.
Well, greetings, everyone. Thanks for joining our Canio Zoom session. I'm speaking to you from inside the bookshop, where we have copies of Larry Goldstone's new book. And we hope you'll order one by calling or putting in the chat or sending us an email for your order. And we can get you signed copies. We are now inviting you in for browsing on a limited basis with masks, please. But we are open every day now from 11 to 5:30. And Sunday and Monday, the hours are from noon to 5. Just want everyone to know that the doors are open. And a special thanks to folks who continued to order from us during the really complete shutdown, very long months. But we so appreciated the community support here at Canio's, and keep it coming. So we look forward to some more Zoom events. You'll see our website, and if you're on our e-list, you'll be getting notifications about those new events to come. I do want to point out there's Larry Goldstone's new book, On Account of Race, and also a book for young adult readers called Stolen Justice, The Struggle for African American Voting Rights. So if there are young people in your life that you want to share this book with, we'd be happy to help you make that happen. So welcome, everyone. If you'd like to get settled and note in the chat where you're joining us from, as Larry Goldstone mentioned, this Zoom format allows us to welcome folks from far and wide. So, so we're happy to have you all this evening. Thank you, Catherine.
Okay, great. Thanks, Marianne. And again, thanks everyone for joining us. I might have a couple of Zoom etiquette things to say before we begin. Please have yourself on mute during the discussion, and questions will be posted in the chat. We'll have time after the two of them talk to answer the questions that you put in the chat. And just another, echoing what Marianne had to say about supporting authors. You know, authors work in a remote room for many, many months, sometimes years. And when their book comes out in the middle of a pandemic, it makes it really quite difficult for them to actually promote it. So support Larry by purchasing the book, hopefully from us. We will have signed copies available too, and allow his works in protecting our democracy to go forward. Anyway, thanks for joining us from the beach or from your garden or after your day of work. I think we're all in for a substantive discussion with two renowned and very well-respected authorities on the subject of voters' rights. The right to vote is taken for granted by some Americans, and the right to vote is relentlessly threatened and chipped away at for many Americans, primarily Americans of color. So thank goodness for historians who make the past visible, and for voting rights advocates who both together insist on ensuring the fundamental right of democracy that every citizen can vote easily and without barriers. So tonight we're honored to have two such individuals with Larry Norden from the Brennan Center and author Larry Goldstone, both in discussion on Larry Goldstone's book, On Account of Race, the Supreme Court, White Supremacy, and the Ravaging of African American Voting Rights. Larry Goldstone's new book reveals the Supreme Court's longstanding support for white supremacy, often under the guise of states' rights. And the book tells the story of the only time in our history when a group of citizens who had been granted the right to vote had it stripped away. And this theft of voting rights was done with the full approval of the Supreme Court. Larry Goldstone's other nonfiction books, in addition to what's behind Marianne on the shelf, include Inherently Unequal, The Betrayal of Equal Rights by the Supreme Court, and 1865 to 1903, Dark Bargain, Slavery, Profits, and the Struggle for the Constitution. Larry has also written several works of fiction. Larry Norden is joining us as the director of the Brennan Center's Election Reform Program. Larry is working to bring balance to campaign funding, very important, and to break down barriers that keep Americans from participating in politics. He works to ensure that the US election infrastructure is secure and accessible to every voter and to protect elections from foreign interference. So we're going to be, Larry Goldstone will start us off with a description of the book and a brief reading, and then they'll be in discussion. Again, post comments in the chat. But for right now, would you please give a very warm Zoom welcome to Lawrence Goldstone and Lawrence Norden.
Thank you, Catherine, and thank you, Marianne. Catherine, you stole my speech. In any event, I haven't done this before. I'm sitting down, which is unusual. I'm wearing glasses, which is unusual. And I'm talking and looking at myself, which is really unusual. But let's give it a shot. I'm a narrative historian, as many of you know, and I've specialized mostly in the Supreme Court, equal rights, and constitutional issues. I'm always looking for episodes in the past that illuminate the present. And voter suppression, which is what this book is about, is a doozy, because voter suppression is going to be one of the key issues going into the November election. It may well determine the degree to which voter suppression is allowed by the Supreme Court, which will be at the center of the action, may well determine whether we have Donald Trump for a second term or Joe Biden is elected president. So I thought it would be interesting to look back at a previous episode in history at the end of the 19th and the early 20th century, when the Supreme Court also was involved in voter suppression with disastrous results, and ultimately resulted in Jim Crow segregation and changed American history, and not for the better. Now, as a narrative historian, I have two kind of tasks when dealing with legal issues. The first is to demystify the legalese. You know, my target is general readers. I'm happy when professors and lawyers such as Larry read my work, but I am targeting general readers, people who are just interested in the subject, and they tend not to want to wade through a Supreme Court opinion. I'm not really all that fond of it myself, but I have no choice. And the other thing to do that I need to do is to make sure it's a story. I want people to want to turn the pages, and you do that by bringing in a lot of the political and social and economic conditions surrounding the cases. And I was really lucky with this book because the material was terrific. I'm going to read a bit I'm going to pick up in the middle of the prologue, and I'm going to pick up right after the Voting Rights Act of 1965 was passed. And as many of you know, the impetus of the Voting Rights Act of 1965 was Bloody Sunday, which was the march over the Edmund Pettus Bridge in Selma, Alabama, led by Hosea Williams and John Lewis, which they were gassed and beaten, and it was a horrific experience. And the thing that made it unique was the entire thing was filmed. And that night, during the premiere of Judgment at Nuremberg on ABC, they broke in, very appropriate movie to break in, to show this incident in Selma, and that aroused the country, and we ended up with the Voting Rights Act. And if a lot of you were thinking, wow, that's what happens with George Floyd, yes, that's exactly what happened. And one can only hope that as a result of George Floyd's murder, we can get legislation that approaches the 1965 Voting Rights Act. So in any event, here it goes. The 1965 Voting Rights Act has been widely considered the single most effective piece of civil rights legislation ever produced in the United States. The law banned literacy tests and many of the other contrivances used in southern states to deny the vote to men and women of color. It allowed the federal government to send election supervisors to any state or county where discriminatory practices had existed as of the 1964 presidential election, or where voter turnout or registration for that election had fallen below 50% of the voting age population. These were called special coverage areas, and in these locations, state and local governments, would be required to gain permission from the federal government before making any change to their election laws or voting procedures. The law was an enormous and immediate success. In Selma, 8 days after President Johnson signed the bill, federal officials helped 381 African Americans register to vote, more than had been able to sign up in Dallas County for 65 years. By Election Day 1965, 8,000 new Black voters helped turn Dallas County Sheriff Jim Clark out of office and into a mobile home salesman. African American voter registration exploded in every state that had been part of the old Confederacy. With increased participation in the electoral process, men and women of color were elected to high public office and have represented the nation in both houses of Congress and even in the White House. John Lewis was elected to Congress from Georgia, where he has remained ever since. African Americans by the thousands served in state and local government. Thanks largely to the Voting Rights Act, the promise of America, it seemed, had tentatively begun to be kept. But the only reason a Voting Rights Act had been necessary in the first place was a series of Supreme Court decisions that began during Reconstruction and ended just after the turn of the 20th century, in which the 9 justices of the nation's highest tribunal had allowed, or more accurately mandated, white supremacist governments in the South to strip from Black Americans that very right, a right that 2 constitutional amendments had been enacted specifically to safeguard. In the guise of a strict reading of the text, like today, and with sham neutrality, like today, Supreme Court justices rewrote the Constitution to fit the racial attitudes of the day and their own. In doing so, the justices allowed popular sentiment and their own notions of racial superiority to overwhelm the promise of equality under the law. The effect was devastating. With the vacuum created by Black disfranchisement, African Americans were helpless to prevent the horrors of Jim Crow from being sucked in to fill it. People of color, most either former slaves or their descendants, had endured beatings, whippings, the destruction of their property, and had even lost their lives in the attempt to secure a right that had been guaranteed to them under the Constitution, but denied by state and local officials. They fought desperately to prevent the right to vote from being systematically rescinded, only to see the Supreme Court uphold the most transparent laws enacted to drive them back into bondage. There is no act more fundamental to democratic government than casting a vote. The ability to do so openly and fairly is considered to a great degree synonymous with freedom, the inability synonymous with subjugation or slavery. That the Supreme Court of the United States was the instrument by which millions of Black Americans were denied this most basic privilege of citizenship is a national tragedy. The only occasion in United States history in which a significant group of citizens who had been specifically granted the right to vote had it then taken away. Until now. On June 25th, 2013, the Supreme Court in a 5-4 decision ruled in Shelby County versus Holder that the formula for determining these special coverage areas was unconstitutional because conditions had improved so much that the formula no longer represented reality. Unless the federal government could demonstrate that these rules were still required, wrote Chief Justice John Roberts in his majority opinion, which was joined by Scalia, Thomas, Kennedy, and Alito. It was a violation of the rights of the states and localities to require them to get permission before they could change their election laws. That states' rights had been the rationale under which earlier courts had allowed white supremacists to rob from Black Americans their access to the political process was no longer germane. Our country has changed, Chief Justice Roberts wrote. Justice Ruth Bader Ginsburg wrote a strong dissent in which she was joined by Justices Breyer, Kagan, and Sotomayor. She agreed that racial discrimination in the ballot box in the states that still required preclearance had decreased, but that was precisely because the law had remained in place. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes, she argued, is like throwing away your umbrella in a rainstorm because you are not getting wet. You gotta love that. If the requirement were eliminated, the dissenters predicted discrimination might well begin. And it will begin again, and so it did. According to the Brennan Center for Justice, the decision in Shelby County opened the floodgates to laws restricting voting throughout the United States. The effects were immediate. Within 24 hours of the ruling, Texas announced that it would implement a strict voter ID law, a photo ID law, excuse me. In 2 other states, Mississippi and Alabama, also began to enforce photo ID laws that had previously been barred because of federal preclearance. Voter ID laws and other restrictions that fall heaviest on the poor, African Americans, and Latinos have been initiated in a number of states, not all in the South. Polling locations have been closed, early voting restricted, and registration rules made stricter, all critics insist, to suppress the vote of certain classes and races. But perhaps the most pernicious effect of Shelby County v. Holder is the renewed perception among those who would discriminate that the Supreme Court is their ally. As a result, they have become emboldened and in many cases perpetrated abuses of power that would have been unthinkable with a different roster of justices. On March 28, 2018, for example, in Tarrant County, Texas, 43-year-old Crystal Mason, a mother of 3, was sentenced to 5 years in prison for voter fraud. Her crime was going to her local church to vote in the 2016 presidential election when she was told that her name did not appear on the voting rolls. And when she was told that her name did not appear on the voting rolls, casting a provisional ballot under her own name for Hillary Clinton. That vote was never counted. What she had not been told was that because she was on federal probation for tax fraud, her name had been stricken from the rolls and her right to vote suspended. Although the prosecutors, conservative Republicans, never accused her of intent in violating the law, they asked for the maximum sentence, which the judge, another conservative Republican, agreed to. Then, in addition to the 5-year sentence from the state judge, at the request of federal prosecutors, Ms. Mason was forced to first serve a 10-month federal sentence for violating the terms of her supervised release. In Iowa, by contrast, a white woman, Terry Lynn Rote, who attempted to vote twice for Donald Trump, which should have been a life sentence in my opinion, was fined $750 and received 1 year of probation. Whether this and similar modern transparencies will ultimately be ruled antithetical to the constitutional guarantees that Americans claim to hold so dear, or be upheld with the same states' rights justifications as ushered in one of the most shameful periods in American history, will depend once more on the will and the honor of the Supreme Court. In so deciding, the justices on the high bench will be issuing nothing short of a practical definition of American democracy. And that's it. And now I'd like to turn it over to Larry Norden for a bit, and he will tell you something about what the Brennan Center is doing. They do fabulous work, so I'm thrilled to do it. Take it, Larry.
Thanks, Larry. And well, first of all, I just wanted to thank Canios, Catherine, Marion for inviting me to be part of this conversation. And Canios is one of my favorite bookstores. I also want to encourage people to buy Larry's book. I agreed to do this conversation before I had read the book, and I was a little nervous that I might not like it, but I was extremely pleasantly surprised that it is so well written and so engaging. And you might think that maybe I just feel like I have to say that because I'm here in this conversation. It really is true. He's a great storyteller, and I do think that this is and we can get a little bit into this, Larry, in our conversation, a part of American history, the kind of post-Civil War period, and part of American history, part of American legal history that a lot of Americans don't know about, and we don't spend a lot of time, certainly in kind of high school history, talking about. And even though I was aware of it, just the reminder of kind of the tragedy of the post-Civil War period in the United States is it's a very, very compelling and important read, and certainly, of course, as Larry said, timely, given what we're facing in 2020. So I'll just talk briefly about the Brennan Center for those who don't know, and I want to jump quickly into the conversation about this very interesting topic. The Brennan Center is a think tank legal institute that's based at New York University Law School. It was founded by clerks of the late, great Justice Brennan, who was on the court at a very different time than the time Larry's talking about in his book. It was a court that really reversed during the time that he was on the court a lot of the awful decisions that we saw from the Supreme Court in the decades following Reconstruction. So the Brennan Center works to, and Catherine mentioned some of the things that I work at the Brennan Center, basically to have a more just and fair American society. A lot of our work we focus on many areas like ending mass incarceration and liberty and national security, but a lot of our work is focused in the democracy space. Just a couple of things that may be of interest right now. As everybody knows, where coronavirus has dramatically changed everything that we do every day. It has it's going to have a huge impact on our elections and the ability of people to vote. One of the primary things that I'm working on right now is just to get more federal funding to ensure that we can actually have a fair, free and fair election this fall. There's so many resources that are needed to make sure that people can get ballots by mail, if they can't vote by mail, that they can vote in person safely. And we're also involved in some of the cases that Larry mentioned that may be critical in determining what this election looks like, that are going to be in front of the courts. Maybe some of them will end up in front of the Supreme Court. I should say, one of the things that Justice Brennan insisted on, he was alive when we were founded, is that that we didn't just follow blindly whatever his opinions were in previous case, in just when he was on the court, but also we're not just a litigation shop. So we do a lot of, as I mentioned, work on legislation and think tank work in developing policies, but we do litigate, and there's going to be a lot of litigation this year. Something that folks may know about is in Florida, and I can talk a little bit about this, last year, the voters by a 2-to-1 margin voted to restore the rights of people with criminal convictions in Florida. Florida was one of the last states, and this is a legacy of Jim Crow, to deny people with felony convictions to vote, which left, I think the number is something like 1 in 5 African Americans without the ability to vote in Florida. So it was an overwhelming victory. The legislature, despite the fact that it was a ballot initiative, effectively tried to overturn that by saying if anybody had any kind of fees that they owed to the court, they couldn't vote, which we calculated, and others, that would leave about 800,000 people without the ability to vote. That we were one of the groups that brought the case against that. We won in the lower court. It's now been appealed. It's going to the 11th Circuit. That may go to the Supreme Court. And there are also going to be a lot of legal battles around mail voting. The Trump administration has brought a lawsuit to prevent the state of Pennsylvania from putting in drop boxes where people can drop off their mail ballots if they don't trust the post office. I don't know if folks saw this, but today the post office said that it may be seriously scaling back on delivery, which could have a big impact on the 2020 election. So we certainly want people to have other options and having to put their mail ballots back in the mail if they want to vote. So anyway, those are some of the things that we're working on. I'm happy to talk about other kind of beyond the 2020 election pro-voter reforms that we're hoping to see that don't rely on the courts. But Larry, maybe we should just jump into discussion. I think what might be useful for people, because as I said, it's not a part of American history that is so well known. Maybe we could just start with you talking about, and I thought you did such a good job in the book of the whole Reconstruction period. There certainly was a recognition after the Civil War about the importance of the franchise to newly freed men. It was really men that were going to get the right to vote, and the challenge of of bringing former slaves and making them full citizens in the United States and part of society, and a knowledge of the likely discrimination that they were going to face.
Sure. I'm on. There's the right to vote. The 4 million newly freed slaves, integrating them into society, was the largest social engineering problem that any society had ever faced in history. And that occupies entire books. The best one, by the way, in my opinion, is Eric Foner's Reconstruction. It's large and terrific. And the misconception most of us had when I went to high school was that Reconstruction was a failure. Well, ultimately it was, but it was sabotaged. It was on the verge of success. But the vote was a different kind of issue. There were two different spurs to make sure that Black men in the South got to vote. The first was the moral imperative, which was very important to a lot of people. But the second was practical. Under the original Constitution, 3/5 of all the Black people in the South, all the slaves, were counted for apportionment, which allowed the South to Southern whites to have a disproportionate number of people in the House of Representatives and a disproportionate number of votes in the Electoral College. After the 13th Amendment, however, there are no more slaves. So 5/5 of all the Black people in the South get to vote. Now, get counted for apportionment, excuse me. If they cannot vote, then the Southern whites get 2/5 more, and when they are readmitted to the Union, which was everyone knew would happen ultimately, unless Black people were voting too, the white Southerners would end up having a greater power in Congress and in the Electoral College as a result of losing the Civil War. Now, this was not anything anyone in the North was going to stand for. So in addition to the moral imperative, they passed 2 constitutional amendments, the 14th and then the 15th, in order to ensure that Black people got to vote. And they did vote. They voted by the thousands. They voted themselves into office. You know, there was also the misconception that that perpetrated by things like Birth of a Nation, that the Black people were illiterate, they didn't know what they were doing, and they voted poorly. It's not true. These new Black voters, even the ones who could not read and write, spend an enormous amount of time learning and studying the candidates, and in most cases voted for white candidates, but many times voted for Black candidates. And Black representation in state and local government exploded, and there were 16 Black men elected to the United States Congress. I mean, at one point in Mississippi, for a very short period, both senators were Black. And in Louisiana, I think for 3 days, PBS Pinchback was the governor. So all of this was moving in the right direction. Education was moving forward. And then first through terror, the Ku Klux Klan and the Order of the White Camellias, and then through voter fraud, the Southern whites, they called themselves redeemers, took over the state governments. And when they had taken over state governments, each state in the old Confederacy rewrote its constitution very specifically to get Black people out of the ballot box, out of the political process. I mean, they announced it in newspapers in terms that I will not use in this. So it was very clear. And then it went to the Supreme Court, and the Supreme Court upheld it.
So, I mean, that was one of the things for me that was so interesting about the early section of this book was how much this struggle was seen in Congress in terms of political power. And really, often the struggles in the law are really about political power. And we're talking now about the legal issues, and you I think frame this correctly. Kind of like often it's framed as a neutral analysis, but we really are talking about, when we're talking about voting rights, political power. And one of the things I wonder is, we are at, and in recent history, it hasn't always been this way, but we do, when we talk about the Supreme Court now, we say they're the 5 conservatives and the 4 liberals, and I think as shorthand people sometimes even say, five Republicans and 4 Democrats, and it's and there's an understanding, at least even if it's not in the decisions themselves, that decisions about voting and voting rights have a direct impact on the political power of the parties. To what extent did in the 19th century cases did you see that kind of a breakdown in how the courts were deciding these issues?
It wasn't the Congress about issues of power. Wow. There are a couple of important things to recognize is that the Constitution is not just America's preeminent legal document. It is also America's preeminent political document. It doesn't simply talk about where power will be or should be. It gives people the opportunity. I mean, the other thing is the Constitution was written to be vague. This idea that you can get an objective, let me just give you a quick example. Article 1, Section 8 gives Congress explicit powers. The last section is that Congress can pass any law necessary and proper to bring any of these powers into fruition. Well, how do you have an objective textualist, originalist, Clarence Thomas, Antonin Scalia, definition of necessary and proper? The example I always give is, for those of you who have young kids, what's necessary and proper to get a young kid to go to bed? Bribe them, give them sweets, let them fall asleep on the couch, yell at them, punish them. In every household, that definition of necessary and proper will be different. Well, the same thing is true of Congress. In 1882, Congress thought it was necessary and proper to pass a law excluding any Chinese immigrants from entering the United States. Now, one hopes that would not happen today. Executive orders would be different. So to deal with all of this before you start talking about the court, you have to get a sense of how political and how much and how malleable the Constitution is. And then you start to go, well, wait a second. If that's true, then isn't every Supreme Court decision subjective rather than objective? Isn't every Supreme Court decision based on what these justices kind of want the Constitution to be or think it should be, as opposed to what it is, if you can't determine, especially for these big cases, what it is? Now, I've been writing about the Supreme Court as a third political branch of government now since like 2005. And initially, when con law professors read it, they hated it. They said, no, you have to do coursework. No, this is now, the Supreme Court as a political entity is a little more accepted. So it wasn't Democrat and Republican in the late 19th century, but it was, the railroads had become popular. There were certain interest groups that had become extremely powerful between, say, 1875 and in through the 1890s into the 20th century, that the court, most of the appointees at the end of it were corporate lawyers, not all, but most, that the court was protecting. And the idea of protecting Black Americans, even though they were citizens, even though they had specific enumerated or guaranteed rights, became unimportant. And they weren't going to be bothered doing something controversial, elevating a class of people to equality where almost the entire country didn't want it to be that way.
Yeah, Adam Winkler, who's actually on the board of the Brennan Center, and wrote a book on corporations. It was called We the Corporations, and made a point that the 14th Amendment, which obviously we all know was specifically written for the rights of African Americans and to ensure that they had their rights. In the years between, I think he said 1868 and 1912, almost all of the cases that were brought under the 14th Amendment were brought for corporations. And there were almost no successful lawsuits on the behalf of African Americans under the 14th Amendment, which is really remarkable. It says something about the court at that time.
There were a lot of cases brought on 14th Amendment grounds. on equal rights, but none of them got anywhere. And a bunch of them I talk about in the book. Adam Winkler's book, We the Corporations, is superb, by the way. And he wrote another book on the Second Amendment called Gunfight, which is also terrific. I know Adam and I have been I've never met him, but we've been going back and forth now for 8 to 10 years, and I kind of knew what he was writing about because it fits in. His is almost the flip side of what I'm writing about, because all of a sudden there's something in law called obiter dicta, which is kind of like an aside. And in an 1876 case, Santa Clara versus Southern Pacific Railroad, Chief Justice Morrison Waite said, there's no point in talking about whether we believe the 14th Amendment covers the rights of corporations. We all believe it. So the jurisprudence went from what it was supposed to be, which was to protect Black Americans, to protect that other persecuted class, the American corporation, where in many ways it still is employed in that regard.
It is kind of remarkable, right? I mean, when you think about where the court is today, we do hear this court has been has lifted up very much the rights of corporations as something that it's extremely concerned about, and a lot of the themes from this period that you're chronicling or seem to be back in terms of what the court has focused on. And one of the things that I think certainly people who went to law school, and you and I talked about this a little bit when I did, a lot of us thought about the court as an institution to protect rights. That's how you get social change done is through litigation in the courts. And in fact, the history of the court is very different. And persuasively make the case here in this book that the court played an extremely large role in kind of destroying all the work that was done during the Reconstruction period. So do you have the view that the court is too powerful in our government?
Yeah, definitely. Now, a couple of other things, not to belabor this, but at the Constitutional Convention, if anybody looks at the Constitution, Article 1 is really long, the rights about the legislature, because they kind of knew they had Parliament to base it on. Article 2, which is the executive, is long, but not as, because they didn't really know. It took 160 votes to figure out how the executive, it was going to be a 3-man, some people, would he be called Your Excellency? So they had an idea, but they knew what they didn't want more than what they did want. Article 3, which describes the court, is this big. It's 6 paragraphs. It doesn't say how many justices should be on the court. It doesn't say what other courts should be there. It certainly does not say that justices should serve for life. It says serve during good behavior. Well, that might mean for life, and it might mean it means you can't get involved in politics. Because in 1803, Justice Samuel Chase was impeached for politicking while he was a Supreme Court justice. So, and the idea that the court could overturn a legislative act as being unconstitutional, that was not, they did not want that. If you read the debates, they talked about the Supreme Court being on a council of approval with the president to have laws passed through, but that right was kind of hijacked by Chief Justice John Marshall in 1803 in Marbury versus Madison, which is the first opening case in every con law book. So the court has carved out a role for itself. Now remember, there's nothing to say that there have to be 9 justices. We started with 6, and then at one point there were 10. So, and only in 1869, after they kicked Andrew Johnson out of office, did they settle it at 9, but that's an act of Congress. So if we want to say, well, Justice Gorsuch shouldn't have been there because Merrick Garland should have been, and Brett Kavanaugh perjured himself, we don't know about the sexual assault, but he certainly perjured himself about his drinking. Well, maybe we should add 2 more judges. And if Joe Biden wins and the Democrats take the Senate, that might be an idea, because the court has become an immense powerhouse that it was never supposed to be. And the other thing that Larry alluded to is, for almost all of our history, except for some brief period that most of us grew up in, the court has been totally conservative, always protecting the status quo, always protecting the powerful, always trampling on the rights of the individual. So if the question is, should we revisit Article 3 and what it gives us the right to do as a people, I think that's not a terrible idea.
And a change in the number of Supreme Court justices only requires a majority of Congress, right, of the two chambers and the.
It does now, thanks to Mitch McConnell.
Right.
It was 60. You know, the whole thing about filibuster, which is another, we could do an hour on that one. But a lot of things were 60 votes, and then Harry Reid, because he couldn't get Obama's judges confirmed, reduced it to 51, mere majority for like regular district court justices. And then Mitch McConnell reduced it to 51 for Supreme Court justices. So yes, 51 senators or 50 senators and a vice president, and you can increase the number on the court to 11. And they say, oh, don't do that. You know, it's going to mess with the political. It's going to make the court too political. You think the court can be more political than it is now?
So I'm curious for your thoughts, and to take us to the current moment. You talked about the importance of the court potentially to this election. What are you concerned about that might come before the court, and do you have a sense of how, you know, I think Justice Roberts surprised a lot of people this year in a number of cases, whether it was you know, the Trump tax return cases. There was an abortion decision that I think people were a little bit surprised at. What kind of cases are you concerned about coming before the court, and how do you feel about how they might turn out?
I actually was not surprised. In fact, I wrote a column on it. What people don't realize is that a Supreme Court era is evaluated in terms of the Chief Justice. It was the Marshall Court and the Tawney Court, Dred Scott, and the Waite Court, and the Berger Court, and the Warren Court for Brown versus Board of Education. It isn't the Scalia Court, and it isn't the Alito Court, and it isn't the Ruth Bader Ginsburg Court. It's the Roberts Court. And everything in history will be evaluated in terms of the Chief Justice, and he feels enormous pressure because, look, he's not an idiot. He sees the tendencies in the White House. So he is totally conservative ideologically, but he's been kind of bouncing back and forth every once in a while to avoid having the court, the Roberts Court, be evaluated. He gave an interview in 2008 when he said there have been 17 Chief Justices and almost all of them have been failures. Well, he doesn't want to be one of them. So the kinds of cases that will come, what you can expect is in all of these states that are trying to suppress the Black and Latino and poor vote, you're going to see an army of lawyers. There will be a lawyer in every polling place. And the second something is, it seems discriminatory, they are going to be asking for emergency writs. The Supreme Court justices are going to be sitting up, each having a circuit. How do I think they'll rule? I think that Justices Thomas and Alito would rule anything on the status quo. And I think they are beyond hope. I think Justice Kavanaugh understands that if the court shifts, he could be in trouble. His seat could be in trouble, so he might be a little more flexible. I think Justice Gorsuch, the ruling on the, I don't see him being all that flexible. The four liberals, of course, will always be there to try to enforce voting rights. And I have a suspicion that Justice Roberts won't let anything too outrageous go by. He'll want, under any other circumstance, if you had any other conservative Republican president, there would be no hope. But this Republican president is not like any other president, thank God. And I suspect he might be a little bit more flexible. You know, the other thing just before, I think everybody wants to be rid of him. I think the Republicans want to be rid of him. If they can keep the Senate and be rid of Donald Trump, I don't think they'd be that upset. The Supreme Court justices want to be rid of him. The military brass want to be rid of him. The intelligence service and the FBI want to be rid of him. So how much effort will be made to keep him in office if it's tenuous? I'm not sure.
So like in a Bush v. Gore situation, you mean where it comes up to the court and they actually may have to make a decision on who's actually president?
You know, that was different. That was a great case. That is 5 conservative justices voting on a liberal principle and 4 liberal justices voting on a conservative principle. Remember, the 10th Amendment, which is the guiding amendment for a lot of conservative justices, is all about states' rights. And the 5 conservative justices didn't allow the state of Florida to make its own rules. The 4 liberal justices, which is about the 14th Amendment, which overrides the 10th Amendment in many ways, applying federal guarantees, voted to allow the state of Florida to do what they wanted. So Bush versus Gore was a great case. That is the purest case to show how political the court was, because every single justice voted against his ideology.
Well, I will say, I think we've already gotten a preview of how some of these cases may be decided from the Supreme Court, and we can talk about what they might be, from decisions that the court has already made this year. And what troubles me is there have been a couple of voting cases related to COVID, right? And the court has, the majority of the court, both of the decisions that I'm thinking of were 5-4 decisions. So the 5 conservatives have made clear we're in an extraordinary circumstance in the United States right now with COVID that doesn't matter to them. If people aren't able to vote because of COVID, too bad. And that disproportionately is going to impact Black and brown voters. We've already seen it. We saw it in Wisconsin, where the court would not extend the mail voting deadlines for those voters. And what happened was what people around the country saw in Milwaukee. You had lines for 7-8 hours in Black neighborhoods. And in Alabama, where there was an attempt, a lower court ruled that they could suspend some of the ridiculous rules that they have in Alabama over having to have a voter ID when you send in your mail ballot, where you have to get a witness or a notary to sign the ballot for you, which is very difficult to do when you're supposed to be staying at home. The court decided 5-4 on this kind of neutrality principle that you talked about, that basically voting rights and the ability to vote really don't matter that much, and could just point to the fact that the rules are the rules and too bad if people can't vote. I think that's probably not a good sign for some of the disputes that we may see going into the election, where we're probably going to have, those are not going to be the last situations because of COVID that people may struggle to vote.
I would not describe myself as optimistic, but I'm uncertain. Clearly, ideologically, we know what these people want. You know, the government, they are reincarnation of the 19th century courts I wrote about. You know, the 5 conservative justices, and they use the flimsiest legal rationales for their decisions, but it isn't about that. It's about, this is the country they think this is the country they want, and they think this is the country that the people want, or the people they care about want. So I don't know, but if the country continues to deteriorate, as unfortunately it may well, given the absolute unwillingness of one side of the political spectrum to actually recognize that there are people getting sick and dying, and the economy suffers as a result, which it will. This isn't either or, it's both. By November, if things are bad enough, maybe you will get a different point of view by some of the justices. I'm hoping, who knows?
So,
Yes,
yeah, I'm going to break in if you can hear me, because we have a question in the chat that's kind of relevant to what you're both discussing right now. Lisa's asking for more specifics. Are there specific cases leading up to this election that we should be watching?
Yeah, so I briefly mentioned a couple of them, and then I can, and Laura, you should jump in. I can talk about some others that I think we may see. But one is this Florida case that I mentioned, where you basically got 800,000 voters in Florida, and it's not clear to us whether or not they're entitled to be registered and vote this November because they have felony convictions. Basically, the Florida legislature said put a kind of poll tax on them whether or not they can vote, even though the voters said they should have the right to vote. The legislature created this new rule that they have to pay for whatever kinds of fees and fines were associated with their arrests. I have to say, as I mentioned, we litigated this case. It's crazy. Like, a lot of these people, it's impossible for them to even find out the debts that they have. So the idea that they're going to be, many of them, of course, can't afford to pay those debts. But I think that is going to, there's a decent chance that's going to go to the Supreme Court. And that could be the difference in Florida. As we know, Florida is often close. I think there's going to be, I mentioned this Pennsylvania case. I think there's going to be a lot of litigation around the rules around casting a mail ballot and when it should count and when it shouldn't count. If a state has a requirement, I mentioned Alabama, if a state has a requirement that you need to get a notary and everybody's told to be able to have your ballot count, everybody's told they should be practicing social distancing, does that requirement still stand? The RNC brought a lawsuit in California, which they actually just withdrew, objecting to the state mailing everybody a ballot that they could vote on. But I'd imagine that we're going to see litigation over things like that, mailing everybody an application, paying for the postage. So those are some of the things. I do think a lot of it is going to be around the rules around mail voting, because normally we don't litigate a lot around that, but in this election we could see 60-70% of people voting by mail.
Iowa's doing the felons, making the felons pay the finance too. I think they're following it along.
Was that right?
I think it's one other state. It's Iowa, and of course Georgia is doing everything they can to suppress black voting, much of which I suspect will be litigated. The Florida case is really interesting because Florida, as you know, has the registration is almost split almost evenly between Republicans and Democrats. Republicans have a slight advantage, but 67% of the people voted. This is a constitutional amendment. Constitutional Amendment 4, which allowed felons who had served out their sentences, other than, I believe, sex offenders and murderers. Any other felon who had served out their sentence and did not owe money in fines could register to vote. And the Republican legislature said, no, well, that should include costs, like what Larry said. So this, you can't have, in the end, we have had white minority government in this country for much of our history. And the only way, we're in a pivotal time here. Reconstruction, the time I wrote about, was another pivotal time when actual democracy almost broke out in the United States. But we still have white minority government, and white minority government is under threat. And because they are a minority, there's only one way they can win in November, and that is to cheat. And all of this is simply cheating. They are trying to stack the deck in their favor. They are trying to make it harder to vote, scarier to vote, riskier to vote, and in some cases, impossible to vote. So again, a lot of the litigation that Larry referred to will be the case. You couldn't have a more obvious set of facts. The question is whether the court will close its eyes and say, oh, no, the law is language, or whether they will look at these laws, as the courts I wrote about did not, and say, hey, look, they came, you know, just one quick aside, in Trump versus Hawaii, Hawaii v. Trump, the court upheld a Muslim ban because they changed the rules a little, even though Trump had been spending all this time against a Muslim ban. They said, well, now the language is different. That is going to be key. Yes, Catherine, sorry.
So just to follow up to that from Lisa, who says that in New York, we allow former felons to vote if they finish their parole. Are there any efforts to allow those on parole to vote? I don't know if either of you are aware of that or not.
Yes, the answer is there was an attempt to bring this up in the state legislature last year. It wasn't successful. I think there may be again next year. I have to say the rules in New York, Brennan Center did some studies on this. They're so confusing. You know, what's the difference between probation and parole, and are you entitled to vote under one or another? And we did a study years ago where we called election offices and asked them, and almost uniformly, you know, am I entitled to vote? I'm on parole, or am I entitled to vote? I'm on probation. They almost universally got the rules wrong in telling people whether or not they were entitled to vote. So if for no other reason, it's much cleaner to just say, once you're out of prison, you've served your time, you're allowed to vote. It just makes it easier for everybody. And you don't have the situation that that Larry mentioned, where somebody shows up and thinks that they're entitled to vote, fills out a provisional ballot, and then is prosecuted and goes to prison afterwards for that. I mean, that's a crazy system. So I'm hopeful. I think, sadly, I'll say legislators in general are can be afraid of touching this, even though you have a situation in Florida where 67% of the voters said voting rights should be restored. I think there is this fear that somehow they're going to be seen as soft on crime or something if they're giving people back their rights.
You know, in Florida, the number of African Americans that would affect was 1/6 of the total voting age, the eligible voting age population of Black people in Florida. 1 out of every 6 Black voters in Florida was affected by that constitutional amendment, or could have been.
Great. Thank you for that, Larry. There is a question from April, who I think may have actually had to hop off the Zoom, but she asked, do you think the contradictory aspects of the Constitution help strengthen our democracy or make it more vulnerable to corruption?
Oh, that is a really good question. I'm sorry she's not here. The answer is both. Because what happened, the reason they wrote it to be vague was that they recognized, these people were very bright in ways that we often don't give them credit for. They recognized conditions were going to change. They didn't leave it vague because they didn't know how to use the English language. They left it vague because they recognized things would be different, and the needs to govern for the Federalist Party, which dominated the Constitutional Convention, were going to change with time. So yes, in that way, of course it makes our democracy stronger. But as Benjamin Franklin says, it's a republic if you can keep it. It also makes you prone to having people who are not particularly enlightened or do not want a democracy to gain the kinds of power that you would not ordinarily want them to have. So the answer is it's both. It depends on the people. We the people. By the way, the original preamble was not "We the people of the United States." It was "We the people," and they listed all the states. But Gouverneur Morris, who wrote the final draft, thought it sounded better, and that's the only reason that it says "We the people of the United States." In any event, it is we the people. We are responsible. If we want gun control, we have to do it. If we want fair elections, we have to do it. Democracy is an unforgiving system. If you stay home or you don't participate, the other guys get to make the rules. And that's how we got white minority government, and that's how it stays in power.
I'll just add very quickly that some of these things can be fixed legislatively, and I do think that we'll see what happens in this next election. But the Democrats have put forth in Congress a very, H.R. 1 was a bill that they passed in 2019. It was the first bill that they passed when they came back to power that would kind of dramatically change some of the rules that have acted as barriers for people to vote. Things like automatic voter registration, really making dramatic changes to the redistricting process, which can often disenfranchise so many people. I think in the past, they haven't been particularly, when coming back to power in the past, they haven't particularly focused on these kinds of rules of the game, whereas frankly, Republicans often have. I mean, as soon as, one of the things in 2010 that you saw, in addition to being extremely aggressive on redistricting, was also immediately putting in a lot of barriers to the franchise with strict voter ID laws and other things. As soon as, and Myra made mention of this, as soon as the Supreme Court struck down parts of the Voting Rights Act, you had states like Texas, Mississippi, Alabama put in crazy ID laws, like you can vote with your gun permit but not your student ID. All of those things were upheld, I do have a question about you have these wave elections. If that turns out to be one that we have this year, if Democrats will view these issues differently than they have in the recent past.
One hopes. It is one thing about being an American history historian. People say, well, this is the worst time ever. Well, it's not a great time, but there have been, most of our history hasn't been smooth, wonderful, peaceful, or fair. And we've managed to work our way through any number of crises, and in most cases come out stronger for it. And this is, the Obama presidency was just incredible. If you would have asked someone in the 2000, are we going to have a black president of 2002 in 10 years? He was, or 8 years, ridiculous. But then what we're seeing is the reaction, because the other side was not particularly pleased to see what Barack Obama represented. So it is a question of how active we are, how much we think in terms of the kinds of government we want, and how much we're willing to do for it. Because the court cases, in the end, the other thing about the Supreme Court is, the court follows public opinion, not the other way around. Everybody talks about Franklin Roosevelt tried to pack the court. What a disaster. Biggest disaster of his presidency. Yeah, except after that, all the Supreme Court decisions started going his way. In the period I wrote about, when Reconstruction was under threat, the radical Republicans, who then were the Party of Equal Rights, would take to come and sit in the court while the cases were being heard as a subtle message that if you don't rule our way, we're going to kick you out. And John Marshall, Marbury versus Madison, was an end run because Thomas Jefferson, who was Marshall's cousin, they loathed each other. And Thomas Jefferson wanted to get Marshall out of the job and put his friend Spencer Roane in. So the idea that the court is impervious to public opinion, Clarence Thomas, yeah, he's impervious to public opinion. But the court in general, if there is enough of a powerful wave, I hate to use the word wave because it's electoral, but a powerful wave of feeling and belief in this country, it is much more likely that the court will not stand in the way.
Thank you. Thank you, Larry. Thank you, Larry. We really appreciate both of your insights into both the past and the contemporary moment that we face. I can't thank you enough for your good works and what you do to help further democracy in our country. For those listening in, join the Brennan Center, make a contribution if you can. Make a contribution to Larry Goldstone by buying his book, gifting it. If you already have one, you can gift it to someone. It's compelling, it's readable, it's what we all really need to know. And unfortunately, too many of us do not know because we're not taught this when we're in school. So listen, you guys did a wonderful job. Thank you so much. Let's all give them a great Zoom welcome, or Zoom thank you. I'm going to unmute everybody.
Thank you, Catherine. And thank you all.
Thank you.
I'm not used to being able to watch a lot of people applaud at once, but there you go.
Terrific.
Yeah, great.
Great job. Thank you.
Thanks, Larry.
Thank you.
Thank you for doing this.
Terrific.
Yeah. So listen, I'd also would like to just to take a moment to tell you about something that's coming up on our calendar that is is relevant to what's happening, what we discussed tonight. We have a film series, Confronting Racism film series, and next Tuesday, the 21st at 7 o'clock, we will be watching together the film Mirrors of Privilege, Making Whiteness Visible. And it's a 55-minute film from World Trust Educational Organization, after which we will have a discussion about the content. So everybody here is welcome to join us. The links are on our website. Thank you for being here tonight, and we'll look forward to seeing you all soon. And Larry Goldstone, hopefully many people will be having you to sign your books at the store, and we look forward to seeing both Larrys very, very soon. Everybody be safe. Marianne, would you like to weigh in with the last comment?
Well, listen, we really enjoyed this discussion. It feels like really just the beginning. Really powerful information, and thank you both for your energy behind it. We really need to stay focused on these issues. So we're grateful to both Lawrence Norden and Lawrence Goldstone, and to all of our participants. So let's keep our eyes open, ears open, and get out to the polls. Thank you both very much. We appreciate it.
Thank you.
All right. Well, everybody have a good evening. Thanks for being here with us, and we'll see you hopefully soon.
Thank you.
Well done.
Good night.